Good morning. Hello, everyone. My name is Christian Tams. Welcome to sunny Glasgow. It's great to see so many of you here for our ICJ assessment. How fit is it at the age of 80? Where does it go? Will it live to see the century? Lots of questions that we pursue. We're in for a packed 2 days, as James was saying, with a sort of a sequence, a sort of quick sequence of presentations. We mostly go panel by panel, encircling the ICJ from different angles. But we have decided to complement this panel structure by a few different perspectives. James has mentioned one of them, a fireside chat towards the end of today. But I mentioned another one. We start with a keynote perspective, with a more general take, I assume, opening avenues for our discussion in the course of the panel debates. I cannot say much more about substantively what will come, because I don't know. I'm in for a surprise, as are you. But I can tell you a bit about our keynote speaker, who's a dear colleague and a friend, Alison Macdonald. Alison is a fellow at All Souls College in Oxford, and that's great. But she's mainly a barrister in London at Essex Court, the leading set of chambers for international law matters. And as a KC and, as the papers say, superstar barrister, she's a leading member of this leading set. Alison specializes in international law, but also in international arbitration, civil liberties, human rights issues, and she practices in all those areas and all those courts that we associate with that, including in big cases that we read about, Mox Plant a few years back, Duarte before the Strasbourg courts, but above all in the ICJ, where she is acting in many of the current and recent disputes, Armenia, Azerbaijan, Sudan, UAE, Chagos in its various permutations. So she comes with a wealth of litigation experience. And Alison, when James and I were thinking of a keynote speaker, we were keen to start us off with the perspective of an advocate who looks to the ICJ from that angle, with that mindset, and with lots of inside experience. We also wanted to be serious about the Scottishness of these conferences. And so we naturally thought of you with perfect Scottish credentials from Kilmarnock, just around the corner, going to school in Ayr, as I learned yesterday, and of course, as one of the leading advocates of our generation. So it's a real pleasure and a real privilege that you have agreed to join us here today. I hope you agree. I assume you agree. If you do so, let's welcome Alison with a round of applause.
Thank you, Christian, for those kind words. Thank you, James, for all the hard work that's gone into organising this, along with the other people who've put together such a fantastic set of panels that I'm really looking forward to over the next couple of days. It's great to be here in Glasgow. The sun is even shining today for our really interesting and timely discussions on the ICJ at 80. And when Christian and James asked me whether I'd give a keynote speech at the start of the conference, it made me acutely aware of the fact that I've never done one before. So thank you for being a patient audience for my first attempt. As Christian said, it's a particular pleasure for me to be here because Glasgow is very close to home. I grew up in Kilmarnock, just down the road, spent lots of time in Glasgow when I was growing up and since. And it's always wonderful to get a chance to come to this thriving and cosmopolitan city. And it's a real pleasure to be here with colleagues and friends from Scotland and from all over the world. And of course, linking this with the ICJ, it is one particular cosmopolitan Scot who connects Scotland with the court. Andrew Carnegie, born in Dunfermline in 1885, emigrated with his family to Pittsburgh when he was 12 years old, made his fortune in steel and other industries, and ended up as the wealthiest American of the time, eclipsing, apparently, even Rockefeller. He then spent his later years giving away an extraordinary amount of his money to philanthropic causes, including founding 2,500 libraries around the world, 14 of which were in Glasgow, a city of which he wrote, "Glasgow has done so much in municipal affairs to educate other cities and to help herself that it's a privilege to help her." And in my own childhood, I spent countless hours researching school projects in the Carnegie Library in Ayr, where I went to school. So Carnegie was approached in the early 1900s with the idea of contributing to a building to house the Permanent Court of Arbitration in The Hague, a court which the Hague Convention of 1899 hoped would end recourse to war as a means of settling differences between states. Now, he actually wanted to endow a library of international law. He wasn't so much interested in paying for the court. Then, as now, it seems, the proper funding of courts can remain a problematic cause, often pushed down the list of financial priorities. But finally, in 1903, Carnegie agreed to pay the huge sum of $1.5 million, which is $50 million in today's money, for a building that would include a court. And the Carnegie Foundation manages the building to this day. Andrew Dixon White, the American diplomat whose efforts were central to the project, delightedly wrote that, and I quote, "After many long centuries, finally a court has thrown open its doors for the peaceful settlement of differences between peoples." Then, of course, the building came to house the PCIJ, and 80 years ago, its successor, the ICJ. And whenever I go to that beautiful little palace in The Hague, the image of which has become synonymous with the court itself, it makes me happy to think that it owes its existence to Scottish hard work and generosity. Now, Andrew Dixon White, when selling the idea of the court building to Carnegie, wrote that, and I quote, "Were such a fabric to be created, men would make pilgrimages from all parts of the civilized world to see it. It would become a sort of holy place, prized and revered by thinking men throughout the world, and to which, in any danger of war between any two countries, the minds of men would turn naturally and normally." Now, is this how things have worked out for the project? Certainly the first part of the prophecy is correct. The building receives a steady stream of visitors from all around the world, not only for hearings at the PCA and the ICJ, but also other projects such as the Hague Academy, diplomatic visits, and interested tourists. But is the ICJ, White's words, prized and revered by thinking people throughout the world? I'm going to turn men into people throughout to update his rather dated use of language there. Do people's minds turn naturally and normally to it in any danger of war between two countries? That's what I want to briefly consider this morning, with some reflections which I hope could help to set the scene for the discussions which we're going to have today and tomorrow. Looking at the conference programme and thinking more generally about the current state of play in international law, I think we're all engaged in a very delicate balancing act these days. We all believe, and I'm going to hazard that assumption about all of us in this room, that the rules-based international order is a good one. Depending on our ages, there may have been short or perhaps longer periods of our professional lives when it's been secure enough that we almost took it for granted. Though I came to the bar in 2000, so I only really had a year of stability before the so-called war on terror and the invasion of Iraq fractured the post-Cold War consensus of the 1990s. But today, of course, the system is under huge pressure. I don't shy away from using the word attack from multiple directions, including the most obvious attacks emanating from the White House, but also more subtle and perhaps, therefore, more invidious pressures as well. Certainly, I identified with the recent Eagle Talk blog post by Professor Devika Hovel, in which she writes that, I quote, "Being an international lawyer can sometimes feel like being a librarian in the middle of a riot. You are deeply invested in the idea that there are rules, impeccable legal rules, that if followed would make the world a better, more orderly place. You clutch well-thumbed and thoroughly annotated copies of the Nicaragua case, the Rome Statutes, and Oppenheim's international law that explain exactly how everything should work, if only people would stop upturning chairs and setting things on fire long enough to listen." Now, in this situation, it would be foolish and counterproductive, I think, to be delusionally upbeat. But nor can we achieve anything if we surrender to despair. And in this respect, I think we can all be inspired and galvanized by those, including many children and young people, who are working to use the law to combat the climate crisis. They show us that we can have sober realism about how close we are to the point of no return. We can be aware of the fact that things are really not guaranteed to be okay. But at the same time, we can be determined to do everything we can to bring about positive change. And I think we can learn a lot from these children and young people, some of whom I've had the privilege of getting to know through my work, and whose hard work was also so important in pushing for the ICJ's hugely important advisory opinion on climate change, delivered just 6 weeks ago and hailed as one of the most important decisions in its history. And I know that the advisory opinion will be discussed in one of tomorrow's panels and perhaps in others as well. So in this spirit of cautious optimism, tempered with realism, I wanted to start this morning with an international law success story in which the ICJ has played a vital role in unlocking the peaceful settlement of a long-running international dispute, and which exemplifies, I think, a number of the conference themes. As you will have seen, on the 22nd of May this year, the Prime Ministers of Mauritius and the United Kingdom signed an agreement recognizing the sovereignty over Mauritius over the Chagos archipelago. I've had the privilege of acting for Mauritius in some parts of the story that I will touch on, so of course I start with the necessary disclaimer that everything I say on the subject reflects only my personal views. The Chagos archipelago is, as you know, a group of islands in the Indian Ocean which formed part of Mauritius and which had been administered as such when Mauritius was ruled as colony of France and then the United Kingdom. The archipelago was then excised when Mauritius gained independence in 1968, retained by the UK as the so-called British Indian Ocean Territory, and the largest island, Diego Garcia, leased to the United States to house a military base which remains there to this day. And the entire Chagosian population was removed from the second part of the 1960s to the early 1970s because the United States insisted on the clearing of the entire archipelago. In a cruel twist, this even involved British soldiers shooting and gassing the pet dogs that the Chagosians had been forced to leave behind. Fast forward to 2025. When the agreement was signed and made public in May, parts of the British press made all the predictable fuss about giving away territory and the like. There was also the suggestion that this showed weakness on the part of the Labour government, a ridiculous point when it's in the public domain that, in fact, the bulk of the very constructive negotiations were conducted, in fact, by the previous government. But if you strip away the fuss, of UNCLOS. And I think that that peaceful resolution, especially in the volatile world of 2025, and to show you how long the journey to this point was in legal terms, we need only consider two different sentences. The first is the language that the UK government used consistently over decades whenever the question of sovereignty over the Chagos archipelago arose. This example is taken from the UK's explanation of vote in the General Assembly on the 22nd of May 2019, a vote in which the General Assembly endorsed the ICJ's advisory opinion of 25th of February 2019, which I'll touch on in a moment. The UK said, as it said consistently over decades, the United Kingdom has no doubt about our sovereignty over the British Indian Ocean Territory. The second sentence is Article 1 of the agreement of the 22nd of May 2025. This is headed Sovereignty and states simply, Mauritius is sovereign over the Chagos archipelago in its entirety, including Diego Garcia. Now, from the first of these sentences to the second lies a remarkable legal journey. How did international law build a bridge between these two irreconcilable positions? I'm going to sketch out that journey briefly before thinking about what we learn from it and how it ties into the contemporary world of international law and international adjudication, and in particular, the role of the court. Now, for a long time, the excision of the Chagos archipelago was a classic example of a situation that one encounters a lot in international law, a situation with no obvious means of legal redress. This was especially so since it involved a smaller state pitted against a larger one, who is a permanent member of the UN Security Council, or indeed two permanent members, if we include the United States, the driving force behind the excision of Chagos and the expulsion of the population. And of course, the present day sees many situations in which either permanent members or those in favour of whom a permanent member is willing to use its veto, insulating a situation from action by the Security Council. In such a situation, do minds turn naturally and normally, as White put it, to international litigation? This raises fascinating questions, which again we may touch on during the conference, of when and why states resort to international litigation and whether that is something that has changed over time. Here I would identify a few different factors for us to think about. Firstly, the state needs leadership. I think that any time spent as an international lawyer robs one of any delusions of grandeur, of any idea that lawyers run the show, which they certainly do not. A state needs to have clear leadership from the top and also a good internal legal team, whether it's within the Ministry of Justice, the Attorney General's office, or otherwise. I saw this early on in my career when I was just starting out in the early 2000s, when I was brought in as a very junior member of a legal team helping Argentina with a whole bunch of arbitrations brought against it arising out of its fiscal crisis of 2001. And the total value of those arbitrations was way over the state's GDP. Argentina rapidly built an extremely effective legal team within the Office of the Attorney General, and this was vital in coordinating its defense to all these cases. And I've seen the same excellent internal team building in a really diverse range of states for whom I've had the privilege to work. And in other cases, which I look at from the outside, one can guess at where a state has a great internal team. One recent example that struck me was Germany, in the really detailed and thoughtful defence, if I may say, that it mounted to the application of provisional measures brought against it by Nicaragua. And not to embarrass Christian, but the level of detail that he was able to give in his speech about Germany's due diligence in relation to arms transfers seemed to me to be so clearly the tip of a huge iceberg of information gathering and strategic thinking within the state. So the first point, I think, is leadership. And the second is timing. There are situations where a state may have a possible claim that it could bring, but the timing isn't right, politically or otherwise, for it to do so. In Mauritius's case, for example, running a period where a newly independent state with a lot of things to handle was finding its own. So the time needs to be right for a state to feel able to take a step. Here also, I think the support of other states can be vital. Will the state be alone in its efforts, or has it built the necessary bridges within the international community so as to have the diplomatic and political support it needs? Here again, lawyers play a little part, and the key actors are the politicians and diplomats who manage a state's international relationships. Here, the leading contemporary example is the Ukraine, which has done a remarkable job in building international support and solidarity in its defense against the Russian aggression. And I think in the decade and a half since Mauritius started taking the legal action that I'll talk about in a moment, we've really seen a huge sea change in states' willingness to resort to international litigation. And that's a topic I know we'll come back to during the conference. And this applies not only to the ICJ, but to related actions taken in other international courts and tribunals, including regional human rights courts and interstate arbitration. So we see, for example, hugely important judgment this July of the European Court of Human Rights in the case brought by Ukraine against Russia. We see the ongoing parallel cases between Armenia and Azerbaijan arising out of the Nagorno-Karabakh conflict, spanning the ICJ, the European Court of Human Rights, and arbitrations under the Energy Charter Treaty and the Berne Convention, currently being run by the Permanent Court of Arbitration. So that is timing. The third and fourth points, which I think are closely connected, are strategy and finding a legal foot in the door, if I can put it that way. So assuming leadership and the willingness to take a step, there needs to be a step which can be taken. And it needs to be a sensible step, one hopes, within a sensible game plan. And that's where I think that lawyers can play a part. Nobody has a crystal ball, not even the best lawyers, and I would distrust any lawyer who claimed to own one. But when dealing with long-term international wrongs with no obvious remedy, there does need to be a spark of creativity, which I think the best lawyers have, an ability to think of all the options where the law may be open to develop. And this slightly can-do attitude, if you like, makes me think of a sheet of paper which my 10-year-old daughter recently brought home from school about responding to adversity. One thing it suggested is that you turn "I can't do this" to "I can't do this yet." And I think that's also sometimes the way in international law. It may not give a state a remedy yet, but that might change. In some situations are long games. So turning back to the long game that was the Chagos situation, clearly this was going to be one of those situations where time is needed, given the imbalance of power, the strategic importance of the military base at Diego Garcia, and many other factors. Obviously, one thinks first of the ICJ as a forum, but although both states accepted the compulsory jurisdiction of the ICJ, the inclusion of the so-called Commonwealth reservation in both of their declarations precluded the possibility of automatically referring the dispute to the court, and the UK refused to conclude a special agreement with Mauritius to submit the matter to the court. Now, Mauritius could have bypassed the Commonwealth reservation by leaving the Commonwealth, of course, but UK got wind of this and rushed to redraft its reservation with immediate effect in order to exclude from the jurisdiction of the court any dispute, not only with current, but also with former members of the Commonwealth. And this incident highlights the ever-present danger when contemplating a contentious case of one state pulling the compromissory rug out from under the other one's feet. So were there any other options? I mentioned above the importance of timing and opportunity. The critical point in the Chagos legal saga, in my view, was in 2010, when the then UK Foreign Secretary, David Miliband, declared a so-called marine protected area around the Chagos archipelago. This really was a turning point because it opened up the possibility of a claim under the UN Convention on the Law of the Sea, and Mauritius took the huge decision, always a weighty one for any state, to commence interstate proceedings before a tribunal set up under Annex 7 of the Law of the Sea Convention. And as an interesting procedural aside, Mauritius challenged the appointment of Judge Greenwood, then the UK's ICJ judge, to the tribunal by the UK. And in a very interesting decision, the remaining arbitrators decided that the standards of impartiality and independence that would apply in the general world of arbitration did not apply in interstate arbitral cases, a decision which remains, I think, the leading precedent in this context. So the fundamental question was whether the tribunal had jurisdiction to determine who was the coastal state as part of the UNCLOS claim, with Mauritius, of course, saying that the UK was not the coastal state because it had purported to retain the Chagos Archipelago in breach of the right of self-determination. This was fought out over 3 weeks in wonderful Istanbul, where I had the privilege of being part of a fantastic legal team, which included the late and much missed James Crawford, shortly before his appointment to the ICJ. And speaking of advocacy, I've never seen finer legal argument in any interstate case than James's speech on self-determination. According to the UK, the right of self-determination did not crystallise until 1970. So when Mauritius attained its independence without Chagos in 1968, along with the many other states which gained independence in the 1960s, independence was, it said, granted ex gratia. James noted acidly that, I quote, "there speaks the colonial voice," before saying with a derision which perhaps only he with his boundless intelligence and generosity of spirit, could have got away with, that the UK's submissions had, I quote, adopted 1970 as the date on which self-determination emerged like Athena, fully formed and fully armed into the world. The implication is that it only became a legal right, applicable in the colonial context, once decolonisation was more or less over, and the international community had little need for it, like an exhausted marathon runner arriving at the stadium to find only the cleaners cleaning it up. And I think of this speech when colleagues who practice in the domestic court say to me incredulously, so in international cases, you just read out a pre-prepared speech. And to which my answer is kind of yes, but those who do it well, like James, put a huge amount of skill and learning, in some cases with the greats, really artistry, into the writing of that speech and the delivery. And the image of the exhausted marathon runner turning up late to the empty stadium, to my mind, was such a vivid way of poking fun at the opposing argument. Now, the majority of the tribunal, by 3 votes to 2, decided that the coastal state issue, self-determination, fell outside the tribunal's incidental jurisdiction under UNCLOS to determine title to land. But there was a powerful dissent on this issue from judges Wolfram and Kateka, which I think is a really good example of the power which a dissent can acquire over subsequent years. And I know that's something which, again, is going to be touched on in some of the discussions that are coming up. And the tribunal then did find unanimously that the UK had violated Mauritius's rights in the manner in which it unilaterally moved to clear the so-called marine protected area. So what next? One thing that had developed over time, over the course of the UNCLOS proceedings, was the relationship between Mauritius and the Chagossians, and also between Mauritius and the African Union. The other key change was the increasing role of the General Assembly and the composition of the ICJ, which was perceived as more hospitable to the concerns of smaller states. And I think that's a trend that continues to this day when we see the ongoing cases, both contentious and advisory, that states are entrusting to the court, which has come a long way since the dark days of 1966 and its Southwest Africa advisory opinion, with the outright hostility of Sir Percy Spender and others to the law of decolonisation. So with an ICJ contentious case still out of reach for lack of any jurisdictional basis, naturally thoughts turned to an advisory opinion. And this was my first experience of the long process of diplomacy, of coalition building, of drafting a resolution and helping to shepherd it through the 6th Committee and ultimately to the General Assembly itself. Here, the crucial factor in my view was that the African Union took up the cause and sponsored the draft resolution, seeing it as a matter of ending British colonial rule in Africa. And that was hugely influential in the General Assembly. Another interesting factor was that this was, of course, less than a year after the Brexit vote in the UK. And very interestingly, the EU, of which the UK remained a part at that point, chose not to direct its members to vote in support of the UK in the General Assembly. So there was a free vote for EU member states, which was unusual and a bit of a slap in the face for the UK. So finally, on the 22nd of June 2017, the matter came to a vote. The resolution was comfortably passed with 94 votes in favour, 15 against, and 65 abstentions. The abstentions included most of the EU member states, who, as I've said, had a choice of how to vote. Now, the maths, which I've done, is that if the EU had directed them to back the UK, the resolution would still have passed, but by a narrower margin. And one lesson I think to take away from that is that an issue in international law and politics is never isolated, and that states can gain or lose support based on wider factors than the principles and interests at stake in a particular vote. So then on to The Hague for hearings in September 2018. The Chagos advisory opinion was delivered by the court on the 25th of February 2019. I know you'll all be familiar with it, so I won't go through it in detail. The key findings of the court were that, firstly, the detachment of the Chagos archipelago, I quote, was not based on the free and genuine expression of the will of the people concerned. Accordingly, it said, the process of decolonisation of Mauritius was not lawfully completed when it acceded to independence in 1968. This meant that, in the court's view, and I quote, the United Kingdom's continued administration of the Chagos archipelago constitutes a wrongful act entailing the international responsibility of that state. And by the time the court, with the president of the court, President Yusuf, as he was at the time, was reading out these sentences, we were sitting in court hearing this, we could hardly believe what we were hearing. Fourthly, accordingly, the court said, the United Kingdom is under an obligation to bring an end to its administration of the Chagos archipelago as rapidly as possible, thereby enabling Mauritius to complete the decolonisation of its territory in a manner consistent with the right of peoples to self-determination. And as I said, as we heard President Yusuf reading the judgment, sitting in the court, I really did have tears in my eyes. People don't talk much about the role of emotion in the process of being a lawyer. And of course, we do our jobs as neutral advocates, without fear or favour, and I take pride in that. And one likes or agrees with the point one is arguing, more in some cases than in others. But here, a lot of people had poured 9 years of work into this case. And this is one of the cases that I think really touched the hearts of everybody who had the privilege of working on it. There are a few points I'd pick out from the advisory opinion that I think are relevant to our discussions today and tomorrow. Firstly, I think this was the first advisory opinion, if you like, of the contemporary era of advisory opinions. Before that, the last ones were Kosovo in 2010, the Wall in 2004, and then nuclear weapons back in 1996. There had been nothing touching on self-determination or Africa specifically since Namibia and Western Sahara in 1971 and 1975, respectively. Secondly, the process had widespread participation by states, around 30, which is less, of course, than the bumper crop at the climate advisory opinion, but I think still marked a point where states realised the strategic opportunities presented by such cases, both as a chance to be good global citizens, but also to help shape the law on issues which affect their own interests as well. One example is Cyprus, where the United Kingdom created so-called sovereign base areas when Cyprus gained independence, and Cyprus staunchly supported Mauritius through the advisory opinion process. Thirdly, the process involved civil society, and for example, one striking feature was a video played by Mauritius during its submissions at the oral hearing of a woman called Marie Elise, who had been forcibly removed from the archipelago as a young pregnant woman, explaining in Creole what had happened and how it had impacted her, including the loss of her unborn baby, and how it had impacted her community more broadly. And I was really interested when I went to a workshop in Berlin early last year, organised by the NGO Legal Worldwide, and groups representing Syrian survivors of torture by the Assad regime, which at that time seemed impregnable, though it was to fall by the end of the year. And they saw Chagos' advisory opinion as an important example of the human dimension being made clear to the court amidst the sometimes dry process of legal argument. Fourthly, picking up on the human dimension, Judge Robinson gave a very thoughtful, powerful separate opinion in which he situated the Chagos story within the history of colonialism. The opinion begins by noting that, I quote, these proceedings present a snapshot of the classic workings of a political and economic system, European colonialism, that in its application wrought more death, injury, suffering, and injustice than any other in the history of mankind. And Judge Robinson really brought to the fore the human rights issues which the case raised, including setting out Ms. Elise's testimony in full. And I think this is an eloquent example of one of the topics for the conference, which is the contribution that separate opinions in the ICJ have made to the advancement of human rights. Interestingly, as an aside, Judge Yusuf himself, who presided over the court at that time, also gave a very fine, in my view, separate opinion in May of this year in the Gabon Equatorial Guinea case, arguing that the court should move on in the 21st century from the use of colonial language and legal terminology. Judge Yusuf starts his separate opinion by stating forthrightly that, I quote, "I think it's high time that the court set aside in its judgments on territorial disputes between African states the use of colonial law, colonial terminologies, and the legal concepts and rules attaining to it, which were elaborated in the 19th century under the public law of Europe, which some European scholars referred to as international law, but was a law applied only among a self-styled club of so-called civilized nations." Judges Shui and Sladi also wrote very thoughtful, separate opinions on the same issue, and all three of these are very much worth a read in my view as fascinating reflections on the language of international law and its origins. Now, one question that's very live in this period of advisory opinions is, what are their consequences? The ICJ, as I've said, was very prescriptive in its conclusions in the Chagos case about what the UK had to do, just as it has been, for example, in the recent occupied Palestinian territory advisory opinion. The court stated that the United Kingdom has an obligation to bring to an end its administration of the Chagos archipelago as rapidly as possible. However, the UK was very quick to point out, correctly, that the advisory opinion was just that, advisory, not binding as in a contentious case. So the UK argued this meant that it did not have to comply with it, which indeed it did not for the next 6.5 years. Now, I think it's worth pausing to ask what advisory really means here. The ICJ had given its view on a range of legal issues. Now, these included when, as a matter of law, the right of self-determination arose, and the factual conclusion that the decolonisation of Mauritius had not been lawfully completed. And it strikes me as odd for states to say that they don't need to act accordingly. They do need to comply with international law, and they have just been told what it is. And indeed, Judge Haidar of ITLOS has put this very clearly in public discussions about the ITLOS advisory opinion on climate change. He has pointed out that the tribunal has given its view on a range of matters falling within its jurisdiction, and there's obviously no prospect of the tribunal saying anything different if it were to be asked the same questions through a contentious mechanism. So in what sense is an advisory opinion non-binding, really? And when the court prescribes action, either through an advisory opinion or through an order in a contentious case, and that action doesn't happen, that of course leads people to say, well, what is the point of the court? What is the point of international law more generally if you can't enforce it in the obvious ways that you can enforce domestic law? And this might be, I think, the central question that leads non-lawyers and lawyers to say, is international law a real thing? Does it really work? And we hear such comments in relation to, for example, the court's order of the 16th of March 2022, ordering Russia to, I quote, immediately suspend the military operations that it commenced on 24th of February 2022 in the territory of Ukraine. The answer, it seems to me, is that first and foremost, it would be good if states obeyed the orders of the principal judicial organ of the United Nations, just as it would be good if they obeyed international law more generally. It would be very good. But even when states are not initially minded to comply, the existence of judicial decisions in both advisory and contentious cases, I think, can play an important part in the longer term. And to make that concrete, in the Chagos case, the first step was that the General Assembly, 3 months after the advisory opinion, passed a resolution which affirmed the court's findings and then demanded a range of specific actions, including that the UK, I quote, withdraw its colonial administration from the Chagos archipelago unconditionally within a period of no more than 6 months from the adoption of the present resolution, thereby enabling Mauritius to complete the decolonisation of its territory as rapidly as possible. So the ICJ's advisory opinion then had the imprimatur of the international community through the General Assembly. And that had various consequences, including apparently small, but to me symbolically important steps, such as the UN updating its official map to remove the so-called British Indian Ocean Territory and to rename it Chagos Archipelago (Mauritius). Likewise, in August 2021, the Universal Postal Union, a UN specialized agency, acting on the basis of the ICJ advisory opinion and the General Assembly resolution, passed a resolution at its Congress to the effect that it would no longer register, distribute, or forward postage stamps issued by the so-called British Indian Ocean Territory. And these developments may sound small, but I think they're also quite symbolic. Although I do have some sympathy for people leading quiet lives in international organizations who suddenly find themselves in the middle of unexpected geopolitical issues. And one saw that in relation to the Universal Postal Union also, for example, in the arbitrations which were brought under its auspices, arising out of Qatar's complaints against 4 other Gulf states for, Qatar said, a blockade which they commenced in 2017. And again, highly political issues arising in what one might have thought of as the sedate world of stamps. Now, sadly, in the real world, as we've seen in many cases, it's not always the case that the ICJ's advisory opinions or its contentious judgments are acted on straight away. This was certainly the position in relation to Chagos. So the next step is that Mauritius brought a maritime delimitation claim against Maldives before a special chamber of the International Tribunal for the Law of the Sea. What did this have to do with Chagos? Well, the fundamental point, to simplify things hugely, was that whether or not there was a maritime boundary to be delimited depended significantly on whether the Chagos archipelago belonged to the UK or to Mauritius. So the fascinating part of that case is the jurisdictional phase, where the Maldives, of course, overlaid a gold argument, saying that ITLOS did not have jurisdiction to rule on the Chagos sovereignty dispute between the UK and Mauritius, just as the majority of the Annex 7 Tribunal had concluded back in 2015. And in a fascinating decision, the Special Chamber of ITLOS concluded that there was no sovereignty dispute because the matter had been settled by the ICJ in the advisory opinion. So it considered that, in a very interesting paragraph, and I quote, "Determinations made by the ICJ in an advisory opinion cannot be disregarded simply because the advisory opinion is not binding. This is true of the ICJ's determinations in the Chagos advisory opinion, inter alia, that the process of decolonisation of Mauritius was not lawfully completed when that country acceded to independence in 1968, following the separation of the Chagos archipelago, and that the United Kingdom is under an obligation to bring to an end its administration of the Chagos archipelago as rapidly as possible. The Special Chamber considers that those determinations do have legal effect." So this is a really important decision on the question that I raised earlier. What is the effect of an advisory opinion? And what does it really mean to say that it's non-binding? Critics of this decision of ITLOS have said, well, this is an impermissible workaround for monetary gold. But against that is the point I made a moment ago. If the court, having looked at the evidence, decided that the decolonisation of Mauritius was not lawfully completed in 1968, are states free to ignore that finding because the issue came before the court through the advisory route and not through a contentious case? I would suggest no. Now, after that, pressure on the UK continued to mount, and I think this further illustrates the fact that international law can be a long game with many moving parts. And again, some people say, well, what is the point of decisions of international courts and tribunals or of the UN if states don't comply with them? Does that mean that international law is broken or it just doesn't function properly? But I think here there is an important difference between different types of state. The UK does not aspire to be classed with, for example, Russia when it comes to compliance with international law. It aims to lead the way in terms of the international rule of law. And there is a real reputational cost, which one can only assume is felt when the UK fails to act in accordance with, for example, a decision of the ICJ or a resolution of the UN General Assembly. Russia may shrug things off, but the UK really can't. And the new UK government has been very clear about wanting to reset the UK's relationship with international law and the rule of law. So to draw together the threads and offer some very tentative conclusions, I would say that the ICJ, in its Chagos advisory opinion, played a pivotal role in unlocking the solution to a long-running international dispute and paving the way for this year's agreement. But it did not act alone. And as I've tried to sketch out, The law relating to the dispute was considered by a range of international courts and tribunals. And of course, the ICJ only had the opportunity to consider the issue because of the questions referred to it by the General Assembly. So when it comes to international law, court forms part, a very important part, but just a part, of a wider system. And the court itself is acutely aware of that. We can see this very clearly from its recent advisory opinion on climate change. This has been widely praised for a number of reasons, and I'm sure that we'll discuss it across today and tomorrow. I will just highlight two things. Firstly, as to the content of international law, the court was very careful in its approach to the wide and disparate range of sources which it reviewed, clearly with an eye to how those sources fitted together into some, at least vaguely coherent whole. Secondly, as to the range of actors involved in international lawmaking, the court was acutely aware of the wider system in which it sits. We can see this, for example, in its treatment of human rights law and the law of the sea, on which ITLOS and the Inter-American and European Courts of Human Rights have already issued significant decisions. And in the court's concluding paragraph, more broadly, it also situates itself firmly within the UN system, noting that, I quote, through this opinion, the court participates in the activities of the United Nations and the international community represented in that body. And thirdly, finally, the court was realistic about the limits of international law in bringing about change. As it said, I quote, international law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving this problem. A complete solution to this daunting and self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other. And as Judge Tladi put it in his declaration, I quote, I'm pleased that the court, in fulfilling its mandate and responsibility, adopts a robust approach to the obligations of states, and in this way makes a contribution, albeit a very small one, to the crisis facing our planet. Yet, as acknowledged by the court, it should not be forgotten that the court's role is a limited one. No number of advisory opinions, no matter how robust or thoughtful, can save the planet from the ongoing climate crisis. Others have bigger roles to play to stave off the dangers of climate change. And this modesty on the part of international judges reminds me of the wise words of Professor Vaughan Lowe, a dear colleague in Chambers, when writing about international lawyers, where he said, lawyers have a contribution to make. They offer one way of going about resolving some of the most crucial problems that face the world, but it is only one way among many. There are many times when it is much better to call upon a politician, or a priest, or a doctor, or a plumber. And very much in that vein, the court is modest about the roles it can play in solving the world's problems. It's certainly much more modest about its role than Andrew Dixon White was when he was trying to persuade Andrew Carnegie to fund the Peace Palace to house the PCA. But despite the more restrained language, I would argue that what happens in that little palace in The Hague more or less lives up to the dream that he and Carnegie had. We will talk today and tomorrow about the extent to which it does, the extent to which it doesn't, and the challenges for the future. But I would say that thinking about White's aims, now more than ever in times of both war and other dangers and injustices, including the existential threat posed by climate change, people's minds do turn to the law and to the court itself. So with those thoughts in mind, I very much look forward to the discussions today and tomorrow about what has been achieved in this 80 years in that little palace and what may be in store for the future.